Darlene, are you on the line? And if you're having problems unmuting yourself, please press *6. Darlene, are you there? Would you mind leading us in prayer for our first day?
Daisy May. This is Daisy May.
Oh, hi, Daisy.
Hey, Roxanne, this is Mary.
Hi. Iljuice, are you on the line? Is everybody able to hear me?
Yes.
Yes.
Okay. Thank you. Judge Lang? If you could press *6.
There it is. Sorry. Everybody ready? I'm talking away, praying away.
Oh, I'm sorry.
No, it's good. I'm ready if you are.
Okay. Would you mind leading us in prayer?
Oh, sure. 가전 안테스 하나님 일팅가 후긴 있다. 뒷클 담안 있게 안아. Yakit kom pitskui agan uspla shingai hingang angan hogin sudas asink dina gudang yakit di kudingai hits blue ni kudinai platska hawa hanan ikinga. Amen. And I just ask for whatever we're doing today, I ask the Great Spirit to help us. And to help us do it in a good way. And when sometimes we're afraid to ask for help, we don't know which way to turn that direction. So, and to have mercy on all of the things that I've just asked for. Amen. Thank you, Denise.
Thank you, Iljuice. I appreciate it.
Mm-hmm. I'll go on mute again. How's that?
Okay. So, thank you, Iljuice. Everyone should have received an email with the program material for this training. And if you have not, please reach out to Nellie Wassley, the Tribal Justice Assistant Manager, who will be able to get that material to you if you need it. Our first presenter today is Kevin Illingworth. Many of you who have attended the tribal justice trainings before may remember him. Kevin is a professor of tribal government with the Tribal Management Program at UAS. Kevin brings a lot of experience to our trainings, and we really appreciate his continuous assistance. His presentation today will be regarding foundations of sovereignty and jurisdiction, and it begins on page 2 of your presentation material labeled Day 1. Please help me in welcoming Kevin.
Thank you very much, Denise. Can you hear me?
Yes, I can hear you.
Wonderful. Well, thank you, everybody. I really want to thank you for allowing us into your communities, into your homes, to talk about tribal court development. My presentation is called Foundations of Inherent Sovereignty and Jurisdiction in Alaska. What my goal is, or I think the goal of this presentation is really to two things: to encourage tribes, to encourage all of you in your work on your tribal court development, and also to show what other tribes around the state of Alaska are doing as far as tribal court development. What I mean by that is we all know Alaska is a huge state, and there's so many tribes, 229 tribes in Alaska doing hundreds of different things. And so I'm going to try to make some sense and talk about the different things that tribes in Alaska are doing. I also do want to be very respectful of our limited time while trying not to talk too fast. We do have question and answers after each presentation, and so I am going to allow the time for question and answers. So please, if you do have questions, jot them down, and we will have time right after this presentation for questions. So this word jurisdiction, we hear this word jurisdiction a lot, and it's used by lawyers in a lot of different ways. I want to break down what does this word jurisdiction mean. And so if you go to the first page of the presentation, what is jurisdiction? Jurisdiction literally means the authority to speak the law. Jurisdiction means authority. But with that, jurisdiction also means responsibility. And it's sometimes difficult for us to know where tribal authority begins and ends. And so I always use as a guiding principle this term responsibility. And this is something that was taught to me by people that I very much respect, elders, saying that the question we need to ask is not do we have authority, but do we have a responsibility? Do we have a responsibility to make sure that our children are safe? Yes. And so we know we have the authority to do child protection cases. We have a responsibility to make sure our communities are safe. So we have an authority to provide for public safety. As we go on to the next slide and talking more about tribal authority, under federal Indian law, tribal governments have authority from two separate sources. One is inherent authority, and this is a recognition under the law by the federal government that tribal authority existed before the formation of the United States and continues to exist today. This is our inherent sovereignty, our inherent authority that was never taken away. Yes, it was repressed, and yes, it hasn't been exercised completely. But federal Indian law recognizes that you have all of the inherent authority that your ancestors had, all of the inherent authority that your tribal governments always had, unless it was specifically taken away. And more on that in a second. But the second source of authority for tribal governments is what we call delegated authority. And this is additional authority that's granted by the United States federal government for tribes to exercise. And we're going to talk about there's some pretty important areas where the federal government has delegated additional authority. Things like the Indian Child Welfare Act or the Violence Against Women Act, supporting the inherent authority that tribes already have in these areas. So if we go to our next slide, perhaps the most basic principle of all Indian law is the principle that the powers which are lawfully vested in an Indian tribe are not delegated powers granted by Congress, but rather inherent powers of a limited sovereignty which has never been extinguished. What is not expressly limited by Congress remains within the domain of tribal sovereignty. This was Felix Cohen. He's considered the foremost expert on Indian law. And he's trying to make very clear that tribes have all the authority that they've always had, unless that's been taken away by the federal government. Now, the next several slides that we have here are talking about the fact that the United States Supreme Court recognizes the inherent authority of tribal governments as well. The tribal governments long predate the United States government. Now, if we go on to the next page, we're talking about jurisdiction over people and jurisdiction over land. I know we're all aware of the lack of clarity over jurisdiction over land here in Alaska, the lack of Indian country. I'm not going to spend time, since we have so little, talking about Indian country in Alaska today, but what I really want to focus on is tribal jurisdiction or responsibility towards tribal members. And what we find that according to the Alaska Supreme Court, and this is supported by a host of decisions, is that Alaska tribes have jurisdiction or responsibility to protect their citizens, their tribal members, regardless of where they're located. So whether your tribal members are in the village, whether they're in Fairbanks or Anchorage, whether they're in San Francisco or Seattle, your tribal government still has legal jurisdiction or a legal responsibility or legal authority over your citizens. Now, if you look down where it says tribal authority over people, citizen-based jurisdiction, there's some quotes from the Alaska Supreme Court that try to explain why tribes have jurisdiction over their citizens, regardless of Indian country. And they say the custody dispute, the custody of Native children, lies at the core of sovereignty. A tribe's inherent powers to determine membership, to regulate domestic relations, and to prescribe rules of inheritance. These are considered the core of sovereignty. And the Alaska Supreme Court went on to say that Northway Village has jurisdiction to hear this dispute because the right to determine custody of Indian children infringes on self-governance. Said in another way, that's the Alaska Supreme Court recognizing the long and terrible history of states like the state of Alaska in taking away Indian children, Native children from their homes. And that infringes on tribal self-governance. That's a threat to the sovereignty of the tribe. And so on the next slide, slide number 10, we have a list of what are considered domestic relations cases. These are cases where everybody agrees that there is clear tribal jurisdiction. So tribes clearly are hearing cases all across the state involving adoption, child custody, child protection, ICWA, marriages and divorces, probate, inheritance, domestic violence, even cultural protections. These are areas that are considered to be domestic relations. Now, I have a couple slides that go into a little bit more detail on some of these types of cases. And the reason why they're there is to show you the language, the quote from the Alaska Supreme Court or from the relevant court supporting tribal jurisdiction. So if we look at the child custody slide, we know child custody cases are cases where we're trying to decide which parent gets custody or how are they going to share custody of children. The Alaska Supreme Court says that we hold that Alaska Native tribes, by virtue of their inherent powers as sovereign nations, do possess that authority. Tribes derive the power to adjudicate domestic matters, including child custody disputes, from a source of sovereignty independent of the land they occupy. This is inherent sovereignty. This is the Alaska Supreme Court recognizing that tribes have inherent powers as sovereign nations to determine the custody of their children. That's followed up on the next slide by adoption. And we know that tribes in Alaska have been doing adoptions for time immemorial. It's such an important part of culture. Tribes can do an order of adoption. So your tribal court can issue an order of adoption. And this is a judge in the Ninth Circuit saying that the state of Alaska, Bureau of Statistics, shall recognize an order of adoption and issue a substitute birth certificate. They must. That language shall means that they must recognize adoptions by tribal courts in Alaska. Our next slide is child protection. And we know tribes are hearing child protection cases across the state, and the state is even entering into compacts with tribes and with regionals to investigate and to hear child protection cases. This is even more important today during our time of quarantine and reduced travel more than ever. We don't want strangers coming into our community. We don't want people coming into that might expose the rest of our community to harm. And so to be able to do child protection investigations, to be able to issue child protection orders from your own community is just so important. This is something that the state of Alaska, the federal courts, all agree that tribes can and should be doing. Now, our next slide says that, of course, in most cases, several tribes can have jurisdiction over their children. And we all know how this happens, right? We have parents from 2 different tribes or maybe grandparents from 3 different tribes. We should have ways to share jurisdiction, to cooperate, to communicate and work together. The last thing we want is to start fighting amongst ourselves. So that slide's really just to encourage us to communicate and work together. Now, aside from, I guess I want to pause there for a second because these domestic relations cases, these cases involving our children and our families, these are probably the most important cases, and these are definitely the cases where we get the most cooperation and are the most common cases heard by tribal courts around the state of Alaska today. But they're not the only type of cases, and we're seeing tribes stepping up and responding to community needs. And there's other types of cases that tribes are hearing in a civil manner in Alaska. And you'll hear me, my next presentation will be on the Indian Civil Rights Act, and I'll talk a little bit more about the difference between criminal and civil jurisdiction. The tribes are hearing minor cases to protect the health and welfare of the tribe. Things like domestic violence, assault, disorderly conduct, vandalism, misuse of firearms, trespass, drugs and alcohol. Tribes are doing these cases, hearing these types of cases to take care of their own communities and make sure that the community is a safe place to live. One of the ways that tribes are responding and one of the tools that tribes have is removal, or sometimes called banishment. So I want to take a quick moment to talk about banishment because we've had a couple banishment cases here in Alaska to give us some guidance on what removal means. And I'm going to try to use the term removal because we're removing somebody from the community.
Thank you.
So removal under the inherent tribal authority means that your tribe orders removal of an Indian from the village, a person from the village, and it's up to the tribe to enforce this removal. This is under your tribal authority, your own sovereignty. Tribes can also order a removal under the Violence Against Women Act. And this would be any case of community or domestic violence, not just against women, but against women, children, men, elders. And all public safety officers must enforce that protective order, including a removal provision. So if you bring a removal under the Violence Against Women Act, you will get cooperation from the state of Alaska. Now, we had one case where a removal happened, and it was in a Togiak case. And I don't want to get into the details of Togiak's case. If you want to, Google it. There's a lot of things that happened. Essentially, a non-native was removed from the community under tribal authority. This non-native sued the tribe and said they violated his rights. the court held, this individual, this non-native sued in state court. State court held that they have that sovereign immunity would not allow the state court to proceed against Togiak, and that if this individual wanted to bring a case, they had to bring the case in tribal court. This is what we call exhaustion of remedies, that the case has to come in tribal court first. So if somebody wants to challenge the authority of your tribal court, they have to do it, the decision in tribal court first. Finally, in our last 5 minutes, I want to talk about an increasingly common type of cases that tribes are getting involved in. And I'm sorry, I want to pause for a second. I use this term cases because I went to law school and I'm trained to think about things as cases. But when I'm talking about tribal authority or I'm talking about tribal courts, I hope all of you know we're often talking about prevention. We're talking about stepping in before things get bad and get to the point of what we would think of as somebody having to go to court. So one area that tribes are doing more in is working with youth. And tribes have inherent authority over their youth the same way they have inherent authority over child protection and adoption. The state court calls us in the place of parents or in lack of parents. The tribe can step in and make sure kids are following the rules. And so things like vandalism, underage drinking, fighting, school problems, tribes are able to step in early before they get into real trouble. And what I mean by real trouble is when they're getting into Department of Juvenile Justice or getting kicked out of school. We should be getting involved before this happens and finding out what can we do to help. This is an area where I've seen a lot of cooperation recently between schools and tribes. The idea of setting tribal courts or circle processes up in the school so that the kids in the school are used to thinking about tribal courts, and we don't think of courts or justice as something that only comes from the state, but rather from something that comes from within the community itself. But finally, I do want to recognize that there are tribes doing all sorts of things around the state of Alaska, and I have a small list on slide 20 of other types of cases that are being heard by tribal courts. Tribes are being asked to hear all types of disputes, sometimes legal contract disputes or employment disputes. Tribes are setting their own environmental regulations through their IGAP programs. Some tribes are regulating their natural resources, stewardship. So whether they own land, many of our tribes own lots of land. Some tribes are that don't own land are cooperating with their corporation. And then we also have tribes that are doing fish and wildlife regulation and protection. Some things under federal law, like marine mammals, where tribes have clear authority, but tribes are also regulating the conduct of their members in other areas and making sure that their tribal citizens are fishing or hunting in an appropriate manner and they're not breaking their traditional rules. I think of this as, especially for our younger people, as education, making sure they're doing things in a good way, in the right way, rather than what they've seen on TV or something else. So I want to end with those because those are some other areas where I think tribes are doing a lot of really exciting things. But the whole purpose of this presentation was to really lay out that there's so much that tribes can be doing in the area of tribal justice and tribal courts, and to really encourage you all in your development. So with that, I see that we're close to the end of the time, and I want to turn it over to Denise for questions.
Okay, thank you, Kevin. I'm sorry, I was talking also on mute. So I'd like to open the floor up for questions or comments to Kevin. And remember to please press *6 to do so, to unmute yourself. Are there any questions or comments?
Denise, this is Daisy May.
Hi, Daisy.
Hi. I have a question, and it's more combined with the issue that we're currently experiencing as tribal members in regards to the COVID issue. How can we ensure public safety with our children, with our school districts, that is combined with the processes with state of Alaska? And I pose this question because I feel as a parent that our children might have to be forced to enter the school classroom when there has been lack due process for parents to have the opportunity to be heard. There has been no fair impartial hearing in regards to the subject. And with the district of our tribal children, I'm concerned about there has been no discussion of any current safety plans. And to close this question, I ask because I have been monitoring and researching the topic very stringently. There has been a remark from some parents that are receiving phone calls from our district office posing, are you going to allow your child to return to school? And keep in mind, if your child does not return into the classroom, OCS will be involved. Thank you.
Wow. So I hear do you want to try to take a stab at that, Kailgit or Kevin?
Well, I keep saying wow. I'm overwhelmed by that. I know locally I can only speak to what's happening down here in Southeast, and we have a really close working relationship with our superintendent, our tribe, our city, and they are having discussions right now here locally about they're handling it very differently because there's more of a collaborative effort, and we have closed our schools. They're not going to open for the fall. So that's really surprising to me. I'm overwhelmed by that. The safety right now of our children is a priority. I can't really speak to your area. I'd have to know a little bit more, but the parents here went to meetings, or actually they were invited for input just like you were, and they just overwhelmingly said no. So there was at least a question to our locals, and the response was so heavy that they made the decision probably about maybe 2 weeks ago, I think, down here. But if anyone else on the line knows, because you are more aware of what's going on in the ABCP region than I am, please feel free to answer. Wow. I'm overwhelmed with that question. Wow.
So this is Kevin. I don't necessarily have a perfectly clear answer because, as you know, this pandemic is a new thing for us. But I do have to say every tribe around the United States is very much worried about the same thing, around not just Alaska, but around the United States. I come down very strongly that your tribe has a responsibility to provide for the safety of your community and specifically for the safety of your children. It makes me angry to think that somebody's threatening OCS action if your children don't go to school, when, of course, you can homeschool your children and keep them out, especially certainly during a pandemic. From the tribal governmental response, I think that there are several things that can be done and resources. I do think the tribal government itself, the tribal council, should insist on being heard and that there be a forum for parents to be heard and that they should be involved. if I hope things can be resolved without conflict. Two areas where I would give for resources is First Alaskans Institute here in the state has been putting together COVID resources and working with communities, especially on food security, but also now schools. And then also NCAI, the National Congress of American Indians, has a whole COVID resources for Indian country page. I try not to give too much advice. My only personal advice right now would be to err on the side of safety and know that you do have the legal responsibility to keep your community safe.
Denise, this is Kailgis. I would ask, like what Kevin's suggesting, with First Alaskans and with anyone else that has a resource. Alex is online as well for outreach, because we don't have that problem down in our area, but right now, I mean, that could be a potential problem for when, for in the future, but I would want someone to call. I would want some kind of way to unite. We have a volunteer group down here. It's called the United Front, where they just get together, the entities get together and talk to each other about some of the things that are concerning us. And there should be some discussion somewhere about this virus, because that is a life-threatening thing, and that we take it very seriously in our villages, as all of you do. And I don't like the idea of being threatened with OCS, because in some communities that's a real threat. They don't have resources to have a way to come back and say, who do I call or what do I do? So I guess we'd all be asked to think our best to actually give an answer by. I'll be looking for that answer in the next couple of days, because it really troubles me. But I like Kevin, you can't give an answer when you don't have one. So thank you.
This is Alex Cleghorn, and something that I would offer is I work at the Alaska Native Justice Center, and with partners at NARF and ALSC, we collaborated with TCC early on in the virus to draft tribal laws around regulating activity, right? So people coming into the village and leaving the village, and who is responsible for monitoring. And we drafted it with an eye towards, our best efforts to make sure it could withstand a legal challenge. And so if you are interested in that as a model, feel free to reach out to me, and I can ask TCC if we can share it, or you can reach out to TCC. TCC is Tanana Chiefs Conference directly. The code, the tribal law that we wrote didn't specifically address school, so it's not directly on point to your issue, but it does address community safety and the tribe's ability to regulate people in order to provide for the health, safety, and welfare of the community.
And Denise, just to follow up, thank you, Alex. That's the kind of stuff that provides some type of relief, or some kind of, I don't know, it just makes me have a feeling of powerlessness, and I don't like that. And I like, how do we help? And I think that's a really good place to start. Yeah. So I think that whatever your area is, too, to share the resources that you do get, and to feel that there is somebody out there trying to address what your issues are. I'll give Liz a call at First Alaskans to see if there's any kind of, just tool or some kind of answer, because that's really disturbing to me. So, yeah.
Hi, everyone. This is Clay, and I'm an attorney with Alaska Legal Services, and I'll just piggyback on Alex's point. If you reach out to Alex, you can also reach out to Alaska Legal Services, but if you reach out to Alex, maybe we could coordinate our efforts. So Alex, feel free to reach out to us at ALSC because we've been drafting codes, safety codes for tribes that are related to concerns about the coronavirus, kind of, tribe by tribe according to tribes reaching out to us and asking. So if anybody reaches out to Alex, and Alex, you want to reach out to us too if you want some help, and we can kind of collaborate on drafting some safety codes that hold up against attack in the court.
This is Alex. Thanks, Clay. As I mentioned, it was a collaborative effort between ANJC, TCC, NARF, and ALSC, that initial drafting. So, of course, it was a group effort.
So this is Denise. I am the manager of the Tribal Justice Department at AVCP, and I just wanted to give everybody else a chance to answer before I did. So myself personally, I actually enrolled my kids in homeschool because of the virus, and it's an extreme step, but I took it just to protect my children. But in regard to codes and such, we have our tribal justice attorney, Winter Montgomery, on staff, who has actually drafted a template emergency declaration and also enforcement codes surrounding the coronavirus. And if anybody ever needs a copy of that, if you'd like some assistance with amending it, the Tribal Justice Department is also a resource for you. With that being said, are there any other questions or comments for Kevin regarding his presentation?
Hello? Hello?
Hello? Hi.
You hear me?
I can hear you now, yes.
Okay, yeah, this is with OCS threatening to take away children, it wouldn't, to me that's always sounded like some kind of violation, especially from ICWA. And then I don't know about the jurisdictional thing with the school, but the school is state property and it's on tribal lands. I don't know how I don't get why OCS would have jurisdiction in that matter.
So, Kevin, I'm going to pick on you. Is that okay?
Yes. So I think starting backwards, OCS could have authority if children aren't being taken care of, and generally speaking, going to school is part of taking care of your children. So that's how the threat could be made. And OCS does have jurisdiction pretty much everywhere in the state to make sure children are being taken care of. But I want to make clear that that jurisdiction is co-equal with tribal jurisdiction to make sure that children are being safe. And so if there is an investigation by OCS into or a report of harm, the tribe should be doing their own investigation and can take authority of the case. So you're correct that it does implicate the Indian Child Welfare Act, or ICWA. And the tribe can get in front of this by starting their own case and doing their own investigation and making sure that the children are being taken care of and are legitimately, in this situation, are being extra safe, not the opposite, being exposed to danger. So I think the takeaway from that I just want to make clear is that while, yes, the state OCS does have authority, that's no more than tribal authority to take care of children too.
Hello? Can you hear me?
Hi. Yes.
Hi, this is Winter. So I practiced in state court for about 8 years doing child in need of aid. So I just want to piggyback on what Kevin said. I agree. So if they brought a case, but it wouldn't pass muster just to say alone that you didn't send your child to school, because that would be under a subsection they're alleging neglect and that you're not providing an education for your child. But neglect in the case law is very clear that there has to be a pattern of neglect, which is more than one item. And so I know we're not completely doing all the training on ICWA, but the standard would be that the child needs to be removed because there's to prevent imminent physical damage or harm to the child, or they have to bring an expert to say that your actions by not enrolling your child in school is going to bring emotional harm and damage to your child. So it's a very high standard for ICWA. So just by making the choice as responsible parents for safety of your children that you want to keep them home or homeschool them during the pandemic, I don't believe a judge would find that met the standard to remove your child. So I think that's fear-mongering. I feel very the same way that Lisa feels, that like threatening people kind of with this power or authority to intimidate them, or for some reason beyond why they would do that, since this is a pandemic going on and a lot of people are making different decisions what's best for their children. So I don't think that I wouldn't be worried that they could actually bring a case in court that is not enough to meet the ICWA removal standard. Okay, thanks.
Hello, this is Artist here.
Hi, Artist.
Hi, yeah, I wanted to make a comment. I was having trouble with my code. I couldn't get in there. So I was kind of late, but I did hear Daisy's concern regarding the OCS trying to get involved with truancy. Yvonne, are you on? Hello? Is Yvonne on?
It doesn't sound like it.
Okay, well, anyway, I worked for OCS for 12 years as a case manager, and truancy is not a child protection issue. So, there's just no grounds for child removal for truancy. But it is investigated, and we used to just talk with the parents, just to encourage them, that they needed their education. But if there was, like neglect, any sign of neglect in the home after investigating the home and walk through, then yeah, there would be concerns right there. And the other comment and question I was going to have, since I got in late, is there a way that I can have the first part of it recapped? Because it wasn't until maybe 1:18ish that I got on finally.
So this training is being recorded, and we're going to post it on the ABCP website when it's concluded.
Oh, wonderful!
Yeah, it'll be there. And I'm really sorry to rush us along. We're a little bit behind schedule, so I'd like to go ahead and welcome the next presenters. Our next presenters are Judge Lisa Ka'iljuis-Ling. Ka'iljuis lives on Prince of Wales Island and is an elected tribal court judge with Tlingit and Haida in Juneau. She is also the executive director for the Foundations of Precious Haida Words. And I'm also welcoming Darlene Daniel, who is the Chief Tribal Court Clerk for the Native Village of Kong-Iganuk. Darlene has been the Tribal Court Clerk for Kong beginning in 2003. While working for the Kong Tribal Court, she also received her associate degree for tribal management with UAA. They are co-presenting on traditional forms of organization, and their presentation will begin on page 22 of today's program material. Welcome, Ka'iljuis and Darlene.
Oh, thank you, Denise. I want to start out in my language. Hadala is atank is ashti kudinat lagan. Pilges kinudu piang yak chinas idu ejang. Lisa Lang yak hate pish kinudu piang hikta handlas ludu ejang. My Haida name is Kailajus, and I really like it. If you could try and use that, that really makes me happy. I am Haida, and I am Sintian. I live in Heidelberg, my home village. Like many of you, I live in my village. I am elected to a regional position as an associate judge. I am a law-trained attorney, but I've spent a lot of my years in my village working mostly on economic development and the revitalization of our culture and our language. So I have two dreams for my community, and I think this kind of helps you understand probably why I'm the person that's going to speak to traditional court structures and something called separation of powers. Before I speak, I want to say my apologies because our presentation came out mixed up, and my co-presenter, Darlene, had brought that to my attention, and I assured her it was going to be taken care of, and it wasn't. So when you get to Darlene, when I go to introducing Darlene, her presentation will start on page 34. So I just wanted to explain that to you before I got going here. And then I will introduce her, and Darlene will talk about a local code for her traditional court, and she will explain that to you because that's really what this today is about, is codes. But I wanted to start my talk by acknowledging that everybody on the line here today has different perspectives. Actually, I'm coming from a perspective like a person who lives in the village. I live in my village. There is no court in my village. And so with that, I have commonality with people who would have to learn about code, to learn what that means. The word code, ordinance, all of those terms are nothing except for what we call your behavior and what is acceptable and what is not. And so when you come from a community that doesn't always write down everything in your language, then you need to learn this this very wonderful method for documenting or writing down all of the things that you need to do. And so I think there's people that are on an intermediate level who have court in their communities, and then there's advanced individuals. Plinkett and Haida is an organization that I work with, and they have a more Western-style court. But I want you to know that since I joined their court, we've gone after a tribal wellness court, and that's what I'm involved in right now. So we're adopting codes, we're writing policy, and today I wanted to explain what the differences are because there's a lot of varieties. You can say your court is traditional, and there can be examples in your area where you know there's no written constitution versus perhaps Bethel, where there may be a constitution that's written every word, everything that you do. So there's very different styles. One's called the traditional tribal court. And I think if you took the two, the traditional tribal court, and you put it alongside of what we consider Western modern court, which would be state court, basically, you're going to come up with a lot of differences. But what I'm doing right now in my world as a judge is I'm going back to trying to implement a traditional tribal court both in my community and at a more regional level. So what does that mean? what does that really mean? I'm looking at something called a peacekeeper's court, and so I'm looking more for things that are based on the language. And when you do go to customary and traditional, it's kind of upside down. The community is the big picture, whereas in the Western picture, it's the individual. It's very, very individual, very, very non-native in concept. And so if you go back to the traditional model, which is what I'm trying to do, because a lot of our languages were stripped from us, and it makes it very difficult when all of your values, all of the ways that you look at the world come from your language. And we are not hopefully basing our values on the English language, because those are values that oftentimes have little to no meaning to our communities. There's also a really, really different approach to healing. You're looking to heal the whole person, whereas if you look in the Western courts, as we know from our high incarceration rates, they're looking to be a winner and a loser. And we oftentimes are not successful in those courts. And I think about that, and I need to say this, that over time and over history, we have not had funding for our courts. We have not had favorable state or federal court decisions to help us to be as powerful as we could be. And what we're left with, when you look at all the rules, like what Kevin was explaining about jurisdiction and about authority and just different concepts, no matter what the rules are, somehow ours were always, when it was related to tribal courts, were less. And this is in the entire United States. So when we go to becoming more sophisticated, and some of us in the regional areas might get to that, working in state courts, and you could hear the conversation with the gentleman and the concerns, and there's people working on these issues that are really doing great work. But as healing goes, as making our people better and well, it's not working, because you can look at the incarceration rates and you can see the people that are in jail, how overwhelmingly sad that is. And so I only wanted to share what I'm doing because I know that it's worth the time and it's worth the effort to go to a model, the traditional tribal court model, that seems to have a healing effect in our communities. And I do advocate for that. One of the things that traditional tribal courts they are led by our communities, and that is one thing. Codes, any code, even if you're working on your very first code and just trying to understand that it's got a structure to it, or you understand that you can have certain authority, but you can't step over the line of your Constitution. There's a bunch of rules, and you have to learn them because you may eventually end up in state or federal court. So you have some rules to follow, but I think overall that the reason I was so happy to be able to speak about this today is that traditional tribal court structure is not a thing of the past. I think it can be very much a thing of the future, especially for youth courts. That's where I'm doing my best. And adult opiate courts is another up-and-coming a way to try to use a healing method. And I remember sitting in law school and them telling me that when I got done with law school that I would think like a white man. I always remember that. And I always smiled really big, and I was like, no, I don't think that's ever going to happen to me. But I do know that it was challenging to keep to believing and really knowing in my heart that because of our language and because of our values and the way that we look at the world, that we are the ones that are going to use those foundations to build something that will help us with the struggles that we have, and that Western justice, you know, we can talk about it all night, but we're going to have to learn to be more sophisticated. They have an idea, and this is the second part of my talk. It's called separation of powers. And, you know, tribes have always had their own ideas of fairness, always. And most of us who live in the village kind of understand what we think is fair and not fair in the way of justice. And a lot of that comes from our values, the way we treat each other, the way we treat the world, the earth, all of those things. But there was a concept when Western-style courts started developing, and in the 30s, the IRA courts, as they're called, were developed, and the majority of them were just kind of copycatted, and they were put down and given to us. And we have one here in Heidelberg. It's very much called a template. It's very much used everywhere, and they gave us this idea of separation of powers, as you know, the whole United States their courts are based on this separation of who writes the laws, who implements the laws, and who administers the laws. So they have a very strong idea, and it's called separation of powers. And so a lot of what they did was really used to take our resources, take our land, take our children, whatever it is. So it really didn't work well, except for to incarcerate people. But anyway, with that, the separation of powers is really a difficult concept for some tribes, because tribes don't necessarily exclude things like prayer. They don't necessarily exclude spirituality or some of the concepts. There's an intermixing of concepts. So I know for me that's always been a difficult thing, but we do have certain rules around that which have to be understood. So it's always good to try to learn as much as you can about all of these ideas that are put on you, but yet my role today is to encourage you to do the work and to learn some of these things that will help bring back not only your language, but the strength that makes your community stronger and healthier. So I'm running over my time, and we talked a lot about, there was some talk about the issues about the virus, and I'm very proud of everybody for asking, and I'm even prouder of the people that are trying to step up to address these issues. I only bring this back out because many communities don't have the expertise. They don't have good people like Alex working at the Justice Center. They don't have legal people able to answer their questions. And when I hear Denise saying, call us, I really want to encourage you to do that, to do the extra work that it takes to make your community a better place. And I have to remember, I'm not just speaking to one person in the audience. There's also people online that are very sophisticated, and they are very, very willing to do the hard work to help you in your community when you don't have those resources. So with that, I thank you all for listening. It's hard to sit on the telephone and listen. And I want to introduce Darlene. She's my co-presenter today. And she was introduced earlier, but I just wanted to mention that I was so absolutely proud of the fact that later this week she will be talking about taking her native language Yupik and putting it into her codes. I think that's invaluable. I think that is the strongest way that you can heal, and I'm very proud of her for that. She helped develop her tribal court back in 2003, and even after the funding ran out, she continued to work on an emergency basis to help children in need or other cases. The judges at that time volunteered their time, and they received donations from agencies to continue. Like was stated before, Darlene received an associate degree for tribal management. Congratulations, Darlene. She enjoys subsistence gathering in the summertime. She likes cutting fish, picking berries for the winter. She's married with 2 grown daughters and 3 grandchildren, and she comes from a very large family of 10 with countless relatives near and far. She is especially valuable because of her work related to traditional tribal courts and how to create codes using your language, your values, and your community-based guidelines. So with that, Darlene, if you're ready, and then as I stated earlier, our slides are kind of confused, which we will fix. We will fix our slideshow, but her presentation starts on page 34.
Hi, good afternoon. Can you hear me?
Yes.
Okay. I mostly wanted to speak about Chapter 20, Liquor and Drug Control on our Tribal Code of Regulations. And I'm going to skip through all these extra pages, and since we're running behind, Gangihanak adopted the Tribal Code of Regulations, Chapter 20, Liquor and Drug Control on August 10, 2017. It was read publicly 3 times in a village meeting and revised as needed. It was passed on the 3rd reading. The majority of our tribal court cases are related to alcohol, and few cases relate to drugs. So they wanted to develop a code of regulations for this chapter. I wanted to point out the differences on the impound fees. On page 2, on the page 2 of the Code of Regulations, on the impound fees, if they are underage driving or speeding or DUI, the fine is $150 if they impound your ATV, and you'll have to get it back. But for a person that is bringing in alcohol, it's a different amount. 500 per bottle of alcohol or an ounce of marijuana or drugs. That's the cost per bottle they charge when they find the illegal alcohol or drug. And then if they impound your ATV or snow machine or boat, it's $500 to get that ATV back or the boat or snow machine. So for importation, that fee goes up to $500. Those are the 2 differences that I wanted to point out. And for this chapter 20, we have a search house at the airport. This chapter 20 is posted at the search house where the person searches the baggage that comes in. And they use this because it says on the 20.4 assurances and search procedures that it does not violate Indian Civil Rights Act, right below the impound fees. So that's the one important part of this chapter. And then they have another page for signing the code. Notice that this code states for our village, we decided that 23 is the age they use to consider minor for minor drinking age. This does not match the state of Alaska legal drinking age, and the tribe has the authority to make their laws and regulations to protect their community members. They were saying that the elder parents used to counsel the young adults even after marriage. Then if they start to hunt and gather for their young family and are able to live on their own, they would move out of the home. They mentioned that in Yupik tradition, the raising of a child it goes past the age of 18, whereas in the Western world out there we consider the 18-year-old as an adult. So those are the two differences that I wanted to point out on these 2 pages. And since those were the main cases that we deal with, I wanted to share the code of regulations that we have on here for those. And do we go for questions after this?
Yep, I was just going to get on there. So I just wanted to say thank you to Ka'el Juice and to Darlene. They're both great resources for the tribes of the AVCP region. Darlene, you know, she's been out in Kong, and, you know, Kong is her home village, but she really did start from the ground up, and she is so willing to help anybody that asks her. So if you need help from somebody who is in your exact position, Darlene is one of our go-to people. Thank you both so much. I would like to open the floor for any questions or comments to Ka'el Juice or to Darlene. And please remember to press *6 to unmute yourself if you're muted. Are there any questions?
I have a question.
Yes. What's your name?
This is Benjamin Charlie from Tuksuk.
Hi, Ben. Go ahead.
Can you be able to hear me? Can you be able to hear me?
Yes.
Hello?
Yes, we can hear you.
Yeah, I got a question now. Since our clerk didn't provide us any drafts of codes and development for this training here, are we supposed to be provided with those materials for this training?
The materials were sent out to whatever email address you registered with. So whatever email address that you put on your registration form, the presentation material should have went to you.
Well, she's on subsisting bear picking, so she didn't provide us. She mentioned about email, but I didn't know which computer she was using, so I'm not too well aware of it. So we're just going to tackle along this and at the same time.
Okay. After the training, I could reach out to you and get you the materials so that you could follow along for the remainder of the 2 days that we have.
All right. Thank you.
No problem. Are there any questions or comments for Ka'el Juice or Darlene?
I have a question.
Yes, go ahead.
Hi, this is Billy Westlock from Mnemonic. You mentioned that a fine for bringing alcohol to your community is $500 a bottle. Are people that aren't your tribal members subject to that fine?
Anybody that brings in the alcohol is subject to that fine.
Thank you. Is there any other questions or comments?
Yes, this is Daisy May.
Hi, Daisy May.
Yes, I have a question. First of all, kuya nga ako in regards to the codes, separation of powers, can you explain the difference between the IRA? IRA does not have separation of powers, but the traditional powers, what are the two differences if it comes to legality?
This is Kailjus. It's going to depend upon what your Constitution is and says, because the IRA ones, like I was saying, probably 60% of our constitutions in Alaska are IRA constitutions. So when Alaska was allowed into, you heard Kevin speaking about Felix Cohan. It's a gentleman that really, really was instrumental in empowering our tribal courts in Alaska, and he tried to do that by creating these IRA courts. And with that, like, for example, I can give you an example of my own hometown. Now, the United States courts are based on separation of powers. There's three distinct areas, you know. But you look at my constitution here in my village, and the executives, who are our tribal council members, are also in my hometown until we change it. They're authorized, they're allowed to be the tribal court, so that there isn't a separate judicial section. It's all together. And that's where there's no separation of powers, at least in my home village. Now, a traditional court would probably, I can't speak for them all, but would more than likely be based more on their history, their culture, their values, which don't operate like separating out the judges from the tribal council members, from the administration. So I know that's very confusing. It was to me when I first tried to figure it out, because you go off and they say, this is how the courts are. So if you go to state court or federal court, it's very separated, called the checks and balances, and it's very, very separated. When you get down to our tribal communities, it's very flexible, but it's very different, because the reason I'm bringing this up is that we are trying to develop here locally a traditional tribal court, and we would still want it, at least in my village, we would want it to be separate. It would probably be not the tribal council. So that was the one. That's a really good question, and it's kind of difficult to answer in a straight path, but that's really how it is explained. And some of those separations we still have to pay attention to. I think they teach you due process, notice, different things. Different rules come up under the Indian Civil Rights Act, and you still have to follow those. But the way that you empower yourself, I think for years in Alaska, we did not understand our inherent power. We were not respected as being able to create and to run our courts. Actually, we weren't funded. There isn't anyone who does a lot of what Alaska did, which was volunteer. There's no one else in the United States who does that. So it's kind of coming back to the way we always were, and realizing that we have our own power. We are very unique, and it really is up to us to understand, first of all, this is very complicated history, but then to also move forward knowing you do have authority and you do have the ability to do to implement your own values and your own traditions within your community. And it's not easy. It's a lot of work, but I was going to ask Darlene about the role of the community and how she got everybody together, because to me that's one of the most difficult things, is to get everybody to understand that it actually takes the whole community, and it takes work and patience to understand and to teach some really complicated things. But our languages and our cultures are complicated too, and so they need to be included in that. Thank you for that question, and I hope I answered you. It's not always easy to answer some of the questions, but it's a very good question. Thank you.
Thank you, Kyle Juice. That was a great answer. Are there any other questions or comments?
I have a question for Darlene.
Yes, go ahead.
Yes, this is Fritz from Kipna. You impound vehicles, and that's probably part in your codes. There was one time we took a Honda key from a minor that was just joyriding, and then their parents were complaining to our administrator that they needed the Honda. And I got a call from the administrator saying, "Oh, give their Honda key back. They need it." How does Kong handle that impound part? Because people will always complain.
We had a minor underage driving case just yesterday, and until they pay the $150 for the impound fee, that vehicle will not be released by the TPOs. And we know the parents will complain too. They did complain. But we're following these guidelines that we have, and if that vehicle is impounded, they have to pay that fee.
Okay, so the administrator doesn't have any authority to, say, give the key back? So that would be tribal judge's side or TPO side authority, jurisdiction?
The TPO holds the key until they pay that impound fee.
Okay. Okay, yeah, that was all. Yeah.
Yeah.
Thanks, Darlene. So now, for the sake of time, I would like to go ahead and move forward. We're welcoming back Kevin Illingworth. Kevin's second presentation today will focus on the Indian Civil Rights Act and Alaska case law. His presentation will begin on page 36 of today's program material. Welcome again, Kevin.
Thank you very much. And I want to thank Iljuice and Darlene for such a great presentation. Really, Darlene, great job, and thank you for walking us through that Title 20 was so good. I kind of want to brag on Darlene and recognize her as one of our very first tribal management graduates, and also encourage everybody that's interested in more of these types of classes from the university. Right now, KUC is trying to start the tribal management program and get faculty there in Bethel. And so any encouragement you could get to the campus would really help us get faculty located there in Bethel to offer more classes and training. So thank you all for having me back. I'm going to be talking about the Indian Civil Rights Act today. There's now two parts to this presentation. You'll see that there's the PowerPoint presentation that begins on page 36. And then I have a handout that comes after that, I guess beginning on page 59. I'm going to refer to both. The handout is an explanation explanation of the Indian Civil Rights Act that was amended by the Tribal Law and Order Act in 2010. This was made by the National Congress of American Indians to help explain these changes to the Indian Civil Rights Act. I'm not going to read through that document because you guys do have this document. Please take the time to read through it. It does a good job of walking you through. Most of the changes in 2010 don't make a really big difference to us here in Alaska right now. And I'll explain more why, but because they had to do more with the criminal jurisdiction provisions. So the Indian Civil Rights Act was passed in 1968. And it was passed because the Supreme Court has held that the United States Constitution does not apply to tribal governments. That the Bill of Rights does not apply to tribal governments. Now, this sounds a little weird, but it's true. Our tribal governments were here for thousands of years before the United States. The United States Constitution is relatively new, and it was only meant to apply to the federal government and to states. So the state of Alaska and state agencies and the federal government, federal agencies, they have to follow the United States Constitution. Tribal governments do not have to follow the United States Constitution. So in 1968, Congress passed the Indian Civil Rights Act in order to impose requirements similar to the United States Constitution on tribal governments. So the Indian Civil Rights Act did a couple things. It gave similar protections, like the Bill of Rights, to tribal citizens, as well as it set the requirements for civil as well as criminal jurisdiction by tribe. So the Indian Civil Rights Act gives our guidelines for what tribes can do through their tribal courts. In 2010, the United States Congress passed the Indian Tribal Law and Order Act in order to enhance tribal authority and tribal sentencing. So in 2010, Congress made this law stronger, gave tribes more power. I'm going to be talking about three different parts of the Indian Civil Rights Act. And on the slide on page 37, the first slide says sections 1301, section 1302, and 1303. So really this is, for those of you that aren't familiar with federal statutes, this really means it's section 1, section 2, and section 3. The 13 is just to keep everything in order. So if you can have both of these documents next to each other, this might be helpful. But what I'm going to do is go over the basics, the most important part of the Indian Civil Rights Act. And what I mean by most important is the most significant to tribal governments in Alaska and the case law from the Alaska Supreme Court and the federal courts about the Indian Civil Rights Act. So section 1302, I'm going to start there because those are what are considered our constitutional rights. And this is what we think of when we say the Bill of Rights, that we have a freedom of religion, that we have the freedom of press, the freedom of assembly, the freedom of speech. All of these are in that number 1 under constitutional rights. I do want to focus on something Ilju said, that tribes are free under the United States law to pray, to start meetings with a prayer. The city, the state may not be able to because of the U.S. Constitution, but there's no establishment clause, is what they call that, in the Indian Civil Rights Act. Tribes can start with a prayer if they want. So the first section sets out our freedom of speech, freedom of press. The second section is what we call our probable cause for issue a search warrant or for any seizure. So in order for your tribal government to issue a search warrant or to seize property, there has to be probable cause. This is very similar to the United States Constitution. Third was double jeopardy. Fourth, we can't compel a person to be a witness against themselves. So if somebody doesn't want to we say plead the fifth, is what we say in federal court. You can't self-incriminate. But most importantly is this idea, I guess, of due process. And I want to really focus, we're going to focus a bit on due process, because due process here in Alaska is particularly important. One of the biggest change in the Indian Civil Rights Act was that it requires additional procedural steps for exercising criminal jurisdiction. So if your tribe is going to be exercising criminal jurisdiction where you're putting somebody in jail for more than 1 year or fining them more than $5,000 per offense, you have to follow these additional guidelines, these additional rules, of the Indian Civil Rights Act. Now, what these additional rules of the Indian Civil Rights Act do is they basically require you to provide an attorney to provide a jury trial. I'm going to say right now that no tribes in Alaska are throwing anybody in jail for more than 3 years, or more than 1 year, or more than a $5,000 per offense fine. So we're not exercising the enhanced jurisdiction under the Tribal Law and Order Act. So what I'm going to be doing is focusing on the original requirements of the Indian Civil Rights Act if we're exercising civil jurisdiction or sentencing somebody to less than a year in jail or $5,000 per offense. So those are our limits that we have that the Congress put on tribal courts. So you're able to incarcerate somebody under the original Indian Civil Rights Act of up to 1 year, and fines or forfeitures of $5,000 per offense. Now, I say per offense, and I want to use Kong's alcohol ordinance as an example. They use $500 per bottle. Well, each bottle would be considered an offense when you're bootlegging those bottles in. So you can see how quickly that $5,000 would multiply. Now, moving on, this presentation is really going to focus on the impacts of the Indian Civil Rights Act in Alaska with a focus on due process. And why are we talking about due process? Because the Alaska Supreme Court has held that if you have jurisdiction and if you provide due process, the state of Alaska must recognize the decisions of your court. So that's really key. The state of Alaska has to recognize our decisions as long as we provide due process. So on page 40, we start talking about what does due process mean. And I want to apologize, this language, due process, it's like a foreign language. All this really means is the process, the legal proceedings, the protocols, if you will, that the court has to follow to make sure that we respect people's rights. So those first rights that were laid out under the Indian Civil Rights Act. It's the process that your tribe provides to make sure that people are treated fairly by your court. And I really want to stress that because that was the purpose of the Indian Civil Rights Act, is just to make sure people are treated fairly before tribal court. My experience has been that people are treated fairly by tribal court. We always give people the opportunity to be heard. We give people a lot more tries than the state court does. But if you'll turn to page 41, here are the 3 requirements of due process. So when you hear a lawyer or somebody talk about you have to require due process, there's just 3 things. First is notice. You have to tell the person about the hearing. Second is the opportunity to be heard. You have to give them a chance to tell their side of the story. But remember, they don't have to talk if they don't want to. And then third, it has to be fair and impartial, meaning it has to be held in a normal fashion and no conflict of interest. Normal fashion, you see, that's kind of a broad term. That just means whatever process you use, you have to be consistent. So if you have a circle, or if you have elders, or if you have your counsel as a court, it doesn't matter. That's up to you. That's sovereignty. It just has to be consistent. So on page 42 is where we talk about notice. Notice really is just letting the person know when and where there's a hearing, as well as what the hearing is about. Now you could give that notice by mail, and the Indian Civil Rights, the ICWA, as many of our tribal courts know, our ICWA requires a certain type of notice by certified mail. For any other type of case in tribal court, notice can be provided in a lot of different ways, through that certified mail, through what's called personal service, meaning you go and tell the person they have a tribal court hearing on this date, or better yet, give them a piece of paper that says when the tribal court hearing is and what's it about. Of course, we can always pick up the phone and call the person. And now even the state of Alaska is doing telephonic hearings. So phone is a very acceptable way to give notice as well. Finally, I have published notice. That's something the state does. We don't see tribes do it very often, but it can be an option. The next slide is the opportunity to be heard. When we say a requirement of due process, the second requirement is the opportunity to be heard. That just means you're giving the person a chance to tell their side of the story. We're not allowed to have secret courts, right? We know that. We can't have court without the person knowing about it and having the chance to come and tell their side of the story. If they choose not to come or they don't want to talk, that's their choice. You're only required to give them the opportunity. The opportunity to be heard also means you can't make a decision before you hear from that other party. And so as a judge, you have to keep yourself open to new evidence, keep your ears and your mind open until that person's had their opportunity to tell their side of the story. And finally, there could be no conflict of interest. And we all hear this term conflict of interest a lot. A conflict of interest is when a judge or a decision maker is too close to that situation to be fair. But it's up to your tribe to define what is too close. The state of Alaska uses first-degree relatives. That might work for your community. You might want to make it something a little more than that. The real idea is that if a judge can't be fair or would be seen as not being fair, the judge should step down and not hear the case. Another judge can hear the case, either another judge from your community or you could ask a judge from another community. The case will still be heard. But if that judge is seen as unfair, that threatens the court if they go ahead and hear that case. It threatens the integrity, the respect that people give to the court. So the judge should step down and not hear the case. My next slide actually has to do with if you're not sure whether there is a conflict of interest. And this is my advice that I give to judges. If you're not sure whether hearing a case would be a conflict of interest, ask yourself two questions. First, can I be fair? Honestly asking yourself, can I be fair? And then second, will the community see me as being fair? The second part of that's a little bit harder. But the idea is if the community doesn't perceive you or see you as being fair, it's better just to step back and let somebody else hear that case so that people do have more respect for the justice system. So the next slide really just is language from a tribal code on what is considered a conflict of interest. And so this includes parents, children, spouses, siblings, grandparents, or grandchildren, or anyone living in the same home. So that's actually broader than the state of Alaska's first-degree relative requirement, trying to be really safe and make sure we don't have a conflict of interest. So while those three are the requirements of due process, again, those three being notice, opportunity to be heard, and a fair and impartial hearing, no conflict of interest. The next slide gives best practices. And I really want to acknowledge Andy Harrington was the person who originally put this together with these three pieces of advice. Andy Harrington was a long time Alaska Legal Services, and he's now counsel at UA. But he says to keep good records, just recording even, but keep good records of your hearing. So this is a good plug for ABCP is going to have a tribal court administration or court clerks training, and I encourage every community to send somebody because keeping records is so important. Second, follow your own court rules. If you have rules, you have to follow them. And so I look again to Kong, and they have these rules, and that's just the way they are. They pass them and they follow them. That's great to hear. Explain your decision. This really is to avoid conflict and getting people to agree with the tribal court. Why did the tribal court make the decision that they did? And then finally, we all know it's so important to protect confidentiality. This is especially true for our court judges and for our court staff, our clerks. Maintaining confidentiality, not talking about court outside of the court is just so important. So all that being said, those are our rules on due process. But if you go to the next slide, we actually have some very strong language from the Alaska Supreme Court. But this due process analysis in no way requires tribes to use procedures identical to ours in their court. That's a quote from the Alaska Supreme Court. And I really want to say we should not be trying to replicate the Alaska court system in our tribal courts. Tribal courts should be different from state court. We already have a state court system. And I really want to reflect, I'm reflecting on what Ildus said earlier. State court, and I'm quoting now again from the Supreme Court, state court should strive to respect the cultural differences that influence tribal jurisprudence, as well as to recognize the practical limits experienced by smaller court systems. My experience is this is something that the Alaska court system does take to heart, and I would encourage as tribal court clerks to reach out to your state court clerk. I would encourage you to reach out to the state magistrate. We all know magistrate judges Garcia, and he has been very, I think, helpful in communicating and helping tribal court. The next slide is another quote from the Alaska Supreme Court. The Alaska Supreme Court says tribes have the power to make their own substantive law in internal matters and to enforce that law in their own forum, their own court. And the court goes on to say, the Alaska Supreme Court says tribal courts may also have jurisdiction to resolve civil disputes involving non-members, including non-Indians, where the civil actions involve essential self-government matters such as membership, or where the exercise of tribal authority is vital to the maintenance of tribal integrity and self-determination. So that's guidance from the Alaska Supreme Court saying that tribes do have authority over non-members and even non-Indians if things threaten self-determination or tribal integrity. And remember, custody threatens self-determination. Domestic relations threaten self-determination. Our very next slide is more from the Alaska Supreme Court. And this is in a case called Parks versus Simmons from 2014. And at this point, the Alaska Supreme Court is getting mad at the state of Alaska. And they're using very strong language. I really want to emphasize. The United States Supreme Court has similarly rejected attacks on tribal court jurisdiction based on allegations of local bias and incompetence. We therefore reject any hint of inadequacy of review that might be inferred from the state's characterization of the Minto Tribal Court as a relational tribal court that applies unwritten cultural law and is unfamiliar with core Western jurisdictional concepts. This is the Alaska Supreme Court telling our previous administrations, you don't get to disrespect tribal courts. Tribal courts are supposed to be applying unwritten and cultural law. Finally, the Alaska Supreme Court went on to say the unsupported averment, that means insult, I guess, the unsupported insult that non-Indians cannot receive a fair hearing in tribal court flies in the teeth of both congressional policy and the Supreme Court precedents establishing the tribal exhaustion doctrine. The requirements for the utility exception are rigorous. A party cannot skirt the tribal exhaustion doctrine simply by invoking unfounded stereotypes. This is the Alaska Supreme Court making very clear that tribal courts have jurisdiction and that everybody has to follow the decisions of the tribal court. Now, if we, our next slide on page 52, I'm going to jump back to the definition of the Indian Civil Rights Act, because this is a change that Congress made to make very clear that tribes, in fact, do have authority, criminal authority, beyond just tribal members. So it says the powers of self-government means and includes all governmental powers possessed by an Indian tribe, their executive, legislative, and judicial, and all offices, bodies, and tribunals through which they're executed, including courts of Indian offenses. The very last sentence is what's important, and means the inherent power of Indian tribes hereby recognize and affirm to exercise criminal jurisdiction over all Indians. That language was added in 1991 to make clear that tribal courts do have, in fact, criminal jurisdiction. Now, here in Alaska, let's go on to the next slide. Here in Alaska, we all know that tribes are exercising civil jurisdiction to ensure public safety. And we're working with the state if there's a serious crime. And I really would absolutely, if you have serious crime, a serious crime that's occurred in the community, we need to be working with the state troopers. But tribes also have their own authority. In 1991, tribes made it clear that tribal courts have criminal jurisdiction. They added that language to fix what was called the Duro case and restored tribal court criminal jurisdiction over all Indians, whether they're members or non-members. This was also affirmed by the Alaska Supreme Court in the John versus Baker case. So if you turn to 54, the Alaska Supreme Court went out of their way to to say the powers of self-government, including the power to prescribe and enforce internal criminal laws, are not such powers as would be necessarily lost by virtue of a tribe's dependent status. Now, I'm not trying to say criminal jurisdiction in Alaska is clear. It's not. However, it is clear that tribes in Alaska, just like tribes everywhere in the United States, do have the authority and the responsibility to provide for public safety and to protect and ensure the rights of their tribal citizens. We think of tribal criminal authority often as being bound to a reservation or to a geographic area, Indian country. As it turns out, we've had circuit courts hold and courts across the United States beginning to hold that tribes are not bound by their reservation. Tribes have criminal jurisdiction, civil jurisdiction over their tribal members regardless of where they're located, just like we heard in the John versus Baker case. Now, again, this is not an area that's clear, and I really encourage tribes to work on developing a tribal justice system, starting with our children's cases, moving on to other cases first. But we do have tribes across Alaska that have tribal police officers and are enforcing criminal laws through their tribal courts. Finally, the very last thing about the Indian Civil Rights Act, the last section is what's called the habeas corpus. And for those of you that have heard from me before, you know I hate when we use Latin. This weird word habeas corpus, corpus in Latin is body, and habeas basically means you can have the body, or the opposite way is show us the body. I know that sounds really weird. Habeas corpus just means somebody that's being incarcerated or held in prison has a right to appeal to federal court. So they can take their case to federal court immediately without having to exhaust tribal remedies. But that is only if somebody is being detained, if they're being incarcerated by a tribe. All other actions of a tribe first must be challenged in tribal court. So if you think back to that Togiak case that I mentioned earlier today, this is the reason why that case was thrown out of state court. It has to start in tribal court first. All actions of a tribe would first be challenged in tribal court. So our next two slides are just recaps. So what type of justice system can a tribe use? Well, you can use what you choose. Your tribal justice system should reflect your values. They should reflect your community. They should reflect your traditions and who you are. It should not reflect the American system of justice. It should reflect you. The only requirement is that you provide that due process. So notice, opportunity to be heard, and then fair and impartial hearing. So I really end with, I hope, words of encouragement. Even though the path forward in tribal justice isn't always straightforward or clear, your tribe does have authority, both recognized by the state and federal government. If your tribe has jurisdiction and if your tribe provides due process, the state of Alaska will respect and uphold the decisions of your justice system. So with that, Clayana, I think we're a little early, so we have plenty of time for questions.
Yes, you're actually correct. We have a good amount of time, so I'd like to open the floor for questions or comments to any of the presenters today. Remember to press *6 if you are muted, and go ahead and ask your questions if you have any.
I have a question.
Yes, I do have a question. In regards to the statement, to the definitions of powers of self-government, does this have any correlation with Public Law 93-638?
So this is Kevin. I'll answer no, it doesn't. Public Law 93-638 is our self-governance contracting law. So it allows us to contract a compact with the federal government. This powers of self-government, when used talking about federal law, really mean the powers to form your own government, the powers to form your own justice system, to make and enforce your own laws.
Are there any more questions or comments?
I have a question.
I got one.
Hi, this is Billy from Imana.
Hi, Billy. I'm sorry. I keep interrupting you.
Oh, no, it's fine. This message or question is for Kevin. This is Billy from Imonic. We're asking people to quarantine when they travel to Imonic. Members and non-members call the tribe to get permission to travel here. And we give out citations if members aren't following those rules. We were told that we can only cite our members because we don't have jurisdiction over non-members. Felt this was a bit unfair because non-members who aren't following quarantine rules put our members at risk. So can we cite those non-members who aren't following the rules?
So Billy, that is a great question, and I'm going to give my opinion is absolutely yes, for the reasons that you mentioned. Now, I do want to be clear, we don't have case law about this because this is a pandemic and this is new. And so the safe answer that everybody gives is that you always have jurisdiction over your members. I would look to the Indian Civil Rights Act in saying that you clearly have criminal jurisdiction over members and non-members, as well as when we're talking about health and safety, the impact is on the members, whether it's a non-member quarantining or not, just as you said. So again, that focus becomes on the tribal member and keeping those tribal members safe, which is the focus of the jurisdiction.
Thank you very much, Kevin. Wonderful presentation.
Thank you. And I would really encourage people to contact Denise because I know Denise can also get the sample codes that Alex was talking about as well and help distribute those.
Hi, this is Estelle from the Native Village of Pineview. One of the things that you can do in your community, as far as the gentleman that asked a question related to citing the members and non-members, is actually work with your tribal police officers, your tribal government to create a resolution to support the citations, and also work with your municipal government if your city has the VPSOs. You can actually work with them to create like a across-the-board type of agreement stating that, yes, you have the authority to cite. That's just one of the ways that I know that some of our villages are working with it.
Thank you.
Thanks, Estelle.
Could you
I'm sorry, I didn't hear your question.
Denise, it's Roberta from Imana. I had a hi. What is the agreement between the tribal court and the VPSO for the lady that just spoke?
So that was Estelle. She's talking about, it sounds like the civil diversion agreement, but Estelle, do you want to answer that?
Can you hear me?
I can hear you. Somebody put us on hold.
I can hear you, along with some music.
Yeah, that's my theme music. No. can still hear the music, but we'll talk about this a little bit more tomorrow. Clay and I are working on a presentation. We're doing a presentation tomorrow on resolving some conflicts in village. With my tribal government and my tribal court, we actually created a consortium, a group of agencies that work directly for the people, whether it's going to be our village, our tribal members, our village residents, and we work with our city too. So we have an agreement between all of us that says that we're going to work together on tribal justice and public safety. And if we have a resolution that's passed by one or both of the villages that we work with, because my village is a displaced tribe and our tribal members live in a different village. Most of us live in Hooper Bay. We create an agreement that says we're gonna our city cop will work with our tribal police officers to uphold any resolutions or ordinances that our tribes deem as like the law, basic tribal law. And you can work with your city or whoever holds your village police officers to agree that any citations that the tribal government, the tribal court, will be held by the city and will be upheld by the city, I should say. And we can talk about that a little bit more tomorrow because we're going to talk about these different intertribal and interagency agreements. But it's something that's really simple. If you want to, I can forward a kind of a template agreement that we've used with some of our villages and our city to Denise, and she can send that out to people that request it.
Are there any more questions or comments? I could get that if you forwarded me that email, Estelle, I could get it out to whoever requests it. Are there any further questions or comments for our presenters today? So hearing none, thank you again, everyone, for joining today's Master Series Training Teleconference. This concludes the session for today. Please let the Tribal Justice Department know if there's anything that we can help you with. We're always here for you. We look forward to seeing you tomorrow's session, which begins at 1 p.m. I hope you enjoy the rest of your day. Thank you again.
Thank you all so much for wonderful, wonderful information. This is Artis. You have a good day.
Have a good day, Artis.
Liana, bye.
Okay, bye.
I've got a question.
Hi, you could go ahead.
Yeah, so we're done until tomorrow, right?
Yes, we're done until tomorrow. It begins at 1 p.m.
1 p.m. Okay. Because we weren't aware what times we were supposed to take. And this is Ben Charlie from Tuksuk.
Hi, Ben.
I had one question to Kevin on his regarding going back to what he mentioned. Any defendant, if there's a court hearing schedule and time and date is given and been notified, he mentioned that defendant, it's up to him, it's his choice to appear or not. Is that correct?
Kevin, are you still on the line? He might have gotten off the phone already.
Okay. There was only one question.
Yeah. So what he was talking about was due process. He was saying that you have to give people a chance to be heard. And if they, you let them know that they have a case and they decide, they don't want to say anything in court, that's their choice not to say anything.
I mean, he mentioned about a person is given a choice to appear or not. That's his choice. That's how I understood.
Okay. I'm trying to see who is on the line. So it is, as long as you provide due process to the person who is being summoned to court, it really is, as long as you provide that due process, it's their choice to appear or not.
Okay, so the only thing I want him to re-explain on that area.
Okay. I could bring that up to him and we could get back to you tomorrow if that's okay with you.
Okay. But as far as I know, one of the coaches on the court hearings, if a defendant doesn't show up, the court could continue the hearing without or with him, with her.
Yeah, it's called an ex parte hearing, and you can do that as long as due process is being followed in regard to letting them know they have a case and what the case is about.
All right, thank you.
Yeah, no problem. Have a good day.
Same to you.